Third parties, grandparents, and other relatives often become the primary care providers and role models for children in situations where the biological parents are missing or unfit due to negligence, drug use, alcoholism, abuse, or financial inability to care for the child. Minnesota Statute Section 257C governs the procedure for petitioning for child custody as an interested third party or a de facto custodian. Whether a petitioner, a person requesting or petitioning the court for custody, is classified as a third-party custodian or a de facto custodian depends generally on the amount of time the child has been with the petitioner and the nature of their contacts. However, for both classes of petitioners, the procedure is generally the same. De facto custodian means an individual who has been the primary caretaker for a child who has, within the 24 months immediately preceding the filing of the petition, resided with the individual without a parent present and with a lack of demonstrated consistent participation by a parent for a period of either 6 months or more, which need not be consecutive if the child is under 3 years of age, or 1 year or more, which need not be consecutive if the child is 3 years of age or older. An interested third party can be a grandparent, aunt, uncle, or other family member or person who can show that the parent has abandoned, neglected, or otherwise exhibited disregard for the child's well-being to the extent that the child will be harmed by living with the parent, and that placement of the child with the individual takes priority over preserving the day-to-day parent-child relationship because of the presence of physical or emotional danger to the child, or both. Minnesota third-party custody law requires a two-step process in which the petitioner, who has satisfied certain statutory requirements, would be entitled to an evidentiary hearing to prove their case. The area of third-party custody is a highly technical area of law, requiring that the pleadings be skillfully written and carefully follow the statute. If the petitioners fail to establish in their petition that they are de facto custodians of the child, or that the placement of the child with the petitioners is not in the child's best interest, the petition may be dismissed. If you are caring for a child whom you are not the biological parent, it is important to file a motion for custody while the child is still living with you. Even though the child may be living with you, you do not have any legal right to make decisions for the child or perhaps to seek any medical care on behalf of the child until the court specifically orders it. If the biological parents take the child before you file the motion, custody is broken and it limits the amount of consistent care you have provided to the child. If you have questions about the criteria and would like to pursue a third-party custody action, contact the family law attorneys at Heimel & Lammers today for a free initial consultation.